So I want to talk a little bit, just to start off, pretty general for our viewers as a little bit of a refresher. Of course, Mr. Reed has been accused of this crime. He was supposed to be executed, I believe, back in 2019. Talk to me a little bit about the work when you all stepped in, a little bit about the work that's been done since then, all the way until now.
Sure. So the Innocence Project has actually been on Mr. Reed's case for many years. But in 2019, the Texas Court of Criminal Appeals stayed Mr. Reed's execution because there was a tremendous amount of new evidence that came forward supporting his innocence. And so the court stayed the execution and ordered a hearing, which we had in the summer of 2021, where we believe we proved very convincingly that he did not commit this crime and that there was really strong evidence that the state actually knew at the time of his trial showing that he didn't commit this crime. And so we are currently waiting for the Texas Court of Criminal Appeals to rule on that hearing and to hopefully hand down relief to Mr. Reed.
And I want to talk about so moving in from that work, we come to yesterday, which was major developments and updates in news in this case. Tell me a little bit about what came out of that SCOTUS ruling.
So the Supreme Court yesterday held that Mr. Reed filed his motion trying to get access to DNA testing timely, that he sought relief in federal courts trying to challenge the state court's denial of access to testing in a timely manner, and it kept the courthouse door open for him. So it means that his case is now going to go back to the Fifth Circuit, where we will have further litigation, and hopefully it gets us one step closer to getting DNA testing one day.
Absolutely. So I want to talk a little bit also. Sorry, wait, I'm skipping around. So I want to talk for our viewers, when you have a SCOTUS ruling like this saying that, hey, he did actually meet, I know it's the statute of limitations, things like that. So that post-conviction DNA testing will be huge. And you just kind of talked about next steps. So go ahead. I know it's going to be repetitive, but kind of tell me that again, essentially, okay, this ruling came down. Does it just come down to DA Gertz's office, or does it come down to the Fifth Circuit? Like, is a new trial what you want, or what would be next?
So what's next for the DNA litigation is that we would go back to the Fifth Circuit to have hopefully further arguments about the merits, about whether he actually gets access to DNA testing. He's been asking for years from the courts to get access to DNA testing on a number of items recovered from the crime scene, most importantly, the murder weapon, which was found near the victim's body, her belt. And so hopefully this gets us closer to getting that testing to happen. Separately, we have litigation in front of the Texas Court of Criminal Appeals that goes to his actual innocence. And, we're waiting on both of these things. So there's two tracks of litigation happening right now.
Absolutely. So the SCOTUS ruling is not necessarily binding in terms of he absolutely will get it, but it's really that huge next step forward because, it's the highest court of the land.
It helps open the doors so that he can continue to fight to get access to DNA testing, and it hopefully helps provide better access to other people in similar circumstances.
And that was one of my questions too. I'm going to go ahead and skip to that one, knowing that, like I just said, the highest court of the land has ruled, aside from three, but has ruled to allow this and recommend this. What kind of precedent does that set for others that feel that they have been wrongly convicted, especially Black men?
What the ruling means is that there's much more clarity now on the ability for somebody who has sought DNA testing in state court and are being denied, and they believe they're being denied unfairly, without due process, to seek relief in federal court. And the ruling yesterday makes clear that that is an avenue that people can pursue. And it also makes very clear the timing of that you need to exhaust all of your remedies in state court before going to federal court.
And in addition, so just a couple more in that DNA testing, I think one of the big things is, of course, many people wonder why he would want that. And yes, it's so he can prove his innocence, as he says. But the big part of that is he's always maintained that it was the victim's fiance. So you all feel that this DNA testing would then open that door to really give that definitive answer or help work towards those answers, right?
That's right. If there is testing on the belt and other items recovered from the crime scene that were clearly handled by the person who committed this crime, as part of committing the crime, that's going to be very helpful in terms of showing who actually was the person who did this to Ms. Stites.
Do you have any concerns that those pieces of evidence have some degrading now that they weren't handled properly? Is that another issue that you might run into with this?
The Innocence Project works almost entirely on cases that are decades old, 20, 30 years, sometimes even more. And in every case that we take on, there's always a recognition that these are old items, that they have been stored for a long time. And the thing with DNA testing is you don't know until you do the testing what it's going to lead to. And we've been really pleasantly surprised in some cases how much DNA remains many years later. And that's what's been so frustrating for Mr. Reed and his legal team is we just want to get to the truth and get to the testing.
And that kind of leads to the question of you all feel that this is truly just his right. Should this technology exist and now you have SCOTUS ruling? I mean, it's more of like for people that may have doubts against his innocence, it's sort of for y'all, it can't hurt, right? It's a simple, let's use the technology.
That's right. I mean, post conviction DNA testing statutes exist because there's a recognition that our system gets things wrong sometimes. And there's a recognition that advances in science should be used to help right those wrongs. So, all we're asking for is what the Texas state legislature has handed down as a right to get access to this kind of testing.
And my last question is, of course, the Bastrop County DA has refused this test for the DNA. And I know you kind of talked about this, but can you just explain for people like me, even that, like,
Sure.
kind of what the holdup was with this? I know that. So, explaining kind of the statute, and did they say that he missed his deadline? Can you kind of explain that?
It's a good question, and it's hard to answer directly because it seems like there's just a real resistance to get to the truth here, as opposed to an actual justified reason not to do the testing. So, our hope is that this ruling gets us a little bit closer to the moment that Mr. Reed's been waiting for well over a decade.
I guess my question is kind of what was their claim? So I get what you're saying, but their
Sure.
claim was that he was missing
Um,
deadlines, right?
I think their claim they've had a number of claims over the years for the reasons why he shouldn't get access to testing. One of them had to do with the timeliness of his request, but that's been made very clear by the text by excuse me, let me rephrase that. The state has had a number of reasons over the years why they have opposed DNA testing, one of which had to do with the timing of Mr. Reed's request. And thankfully, the US Supreme Court's ruling yesterday makes clear that he is absolutely timely in his request.
And the final wrap with it, I know I always lie and say it's my last question,
Okay.
but
That's all right.
good thing we're making good timing.
Yeah.
The final wrap, just to kind of bring it all back together, is of course, should this DNA be tested and should there be enough? I know you got to go back to this Fifth Circuit. Is truly one of the end goals here is to let him have a new trial. And I know the all white jury was something that was a huge part of that case as well. So that really is the end goal, right? To then have enough to say, hey, we need another trial, right?
Absolutely. Our position is that he is entitled to have a fair trial by a jury of his peers, where the state has to put forward evidence that it knows exists that supports his innocence, and where we'd be able to put forward many witnesses who have come forward that directly support Mr. Reed's defense. And so, if we get to that moment, we would be very grateful for it.